For a minute there, I thought, he doesn't need me. He's got it all. What I'm going to do today is talk to you the way I talk to my students. There's no quiz afterward and you don't get a grade. But I believe that history can best be told as a story, and stories about the people who made it happen. I'm here today from Vermont, where the founder of our state, subject to my latest biography, Ethan Allen, did not go to the Continental Congress, didn't come to Boston, but he sent the cannon guaranteeing that the people in Boston could survive the revolution. But then now I'll switch to one of your local heroes. On July 4th, 1776, John Adams, sitting in the Continental Congress in Philadelphia, broke the congressional embargo on personal letters and wrote to his wife Abigail, who was on the farm in Braintree, and he said, "The revolution is now complete. It has taken place in the minds and hearts of the people. All that remains is a war." What I want to say today is John Adams was wrong. The American Revolution wasn't over for another 50 years. And after John Adams and the Revolution and George Washington came Thomas Jefferson and John Marshall, and that was another revolution and another war. History is very personal, and that's why stories work so well with students, I think. It's history that brings alive the people who participated in it, and that's how I've approached the story of the Supreme Court. First, we have to understand who these two people are, who these great figures are. Thomas Jefferson, I'm sure we all know who Thomas Jefferson is. John Marshall, well, Jim has just told us, Chief Justice for 34 years. But what does that tell us about him? What was he like personally? Well, first of all, these two men were cousins who never got along. They didn't like each other. They were so different in personality and in character that I think that had a terrific influence on the struggle between them to define the Constitution and on the struggle that continued until John Marshall died. And on the day he died, Jefferson's followers rang the Liberty Bell so hard in celebration that it cracked. But that was sort of the apostrophe, the end of a long struggle. John Marshall. John Marshall came from a family we in England would have called country squires. His father was a judge. He held all the local offices in one of the western counties of Virginia. In style, well, let's put it this way. Jefferson called him that lax lounger because John Marshall liked good homemade bourbon and liked to buy it for the voters on election day. He liked to wear old clothes when he went into the marketplace in Richmond to do the shopping for his wife, who was ailing much of the time. One day he was walking back from the market, and a young aristocrat came up to him and said, "Young man, I want you to take this turkey to my house." And John Marshall, who at that time was already Chief Justice of the United States, took the turkey, carried it to the man's house, and the man flipped him a coin. John Marshall stuck it in his vest and whistled and walked away. That's John Marshall. Thomas Jefferson stayed on top of Monticello most of the time. He played what was probably a Stradivarius that he got for £5 sterling when a loyalist hawked it to head for England once the war began. He fell in love with his wife as he played the fiddle and she played the piano, which he smuggled into the country even though he had taken an oath not to import anything from the English. He was a great scholar, Jefferson. He rewrote the laws of Virginia single-handedly. 126 bills, the entire criminal code. That was while he was also governor of the state of Virginia and supplying Washington's troops with cannon and ammunition. He never slept, I don't think. His dying words were, "All is circumstance." And I think that's important to remember when we learn what happened to the Constitution. John Marshall never went to school. He was homeschooled for a year. Then a tutor moved in with the family for a year, and then the Revolution came. John Marshall joined the Army, and he was with Washington at Valley Forge during the starving time. And he saw there merchants and farmers from Pennsylvania selling their goods to the enemy, to the British, at a time when the soldiers like Marshall and his men were struggling to stay alive, with 50% of them dying that winter alone, to make a new nation. So he believed that the nation was more important than the state. And Jefferson believed that our country should be made up like a Swiss confederation, that the authority and the power should be with the states. So before they even knew each other on the public stage, they were already diametrically opposed. So when the Revolution was over, at least the fighting, as Jim has pointed out, the Founding Fathers, most of them got together in Philadelphia for 4 months, closed the doors and windows so nobody knew what they were doing, including the other members of Congress. And they hammered out this document with many, many things left out of it. It was just a framework. That's why Madison's called the framer of the Constitution. It did not include the entire judicial system. It did not provide for political parties. That's hard for us to imagine today, but no political parties. Political parties evolved from the rivalries of the Founding Fathers once they tried to run the country. Hamilton against Madison and Jefferson. The two-term presidency was not in the Constitution until it was limited in 1950 after 4 elections of FDR. Washington only stayed on because his lieutenants didn't get along with each other at all, and he was afraid that the Union would come apart after only 4 years. But when they did get together in Philadelphia in 1789, shortly after the inauguration of George Washington, they passed the Judiciary Act of 1789. And basically what it said was there would be 5 justices on the Supreme Court who would also ride circuit as the circuit court judges of the states. That immediately became a problem when John Adams became president, because they rode circuit in their stagecoaches and wagons, reading newspapers and deciding who should be imprisoned under the Alien Sedition Act. And we hear alien and we think of immigration, but the sedition was the most important. Our Founding Fathers had a terrific argument over whether it was safe to criticize the government, especially in print. One of the congressmen from Vermont, we have the only political cartoon from the 1790s, where he fought a battle with fireplace tongs against a congressman from Connecticut who had a poker, which they had taken from the pot-bellied stove on the floor of Congress, to give you some idea of the atmosphere. Now we have metal detectors. But opposite Independence Hall was a field that they kept overgrown because you couldn't see who was having a fist fight or a duel. We need to know these things. Our young people, I think, need to know that these were human beings. These were not icons. These were not gods. Under that 1789 Act, the Supreme Court was established. The Constitution doesn't spell out what it does. It certainly doesn't spell out the doctrine of judicial review. The Constitution does not say that the Supreme Court shall sit in judgment and be the last word on the actions of the chief executive or the executive branch or of the Congress of the United States. The Constitution, as we know it, is a result of powerful men asserting their principles and fighting back and forth over a 30-year period. So I want to take you through a little of that. The first time judges in the new United States tried to declare an act of a legislature illegal happened in Rhode Island in 1786. And the legislature dealt very quickly with the idea of judges reviewing their actions. They made sure that all the judges were dragged before the legislature, they were lectured, and then they were all voted out of office. So as late as 1786, there was no doctrine of judicial review. That didn't happen, actually, until 1801. And in just a few years, in a short frame of time, we have some of the most important developments in the history of jurisprudence in this country. What happened is that Jefferson agreed to be vice president in 1796, just so he didn't have to be in the same room with John Adams. So Jefferson stayed in Monticello through Adams' presidency. And Adams stayed up here as much as he could because of the yellow fever epidemic, etc., in Philadelphia. But Jefferson said that he only agreed to be vice president so that Hamilton couldn't get it. In 1800, Hamilton completely undercut Adams, and it took 35 ballots of the House of Representatives to decide who would be the president of the United States. So when the election of 1800 was over, John Adams and the Federalists were thoroughly defeated. Well, everyone thought they were thoroughly defeated. But a few hours before the end of the last day of John Adams' presidency, he issued commissions to a host of new judges, U.S. Marshals, magistrates, justices of the peace. It was his idea that the Federalists would move into this new and expanded judicial system to oppose Jefferson and his Democratic Republicans. The Supreme Court at that time, as Jim suggested, was not a very fancy affair. Actually, it was that small, dark room under the stairs up to the Hall of Congress. I had a window, and I think one of the secrets of John Marshall's great success as Chief Justice, he only wrote one dissenting opinion out of almost 500 that he wrote himself. He only wrote one because he brought the others, whoever appointed them, whoever they were, around to his point of view. One reason is they deliberated in a tavern where they lived. Washington was a raw frontier town. And Marshall had the idea that if you had to be there on a rainy day, you should be able to have a glass of wine while you deliberated cases. And at one point, he's supposed to have said to Judge Story from Massachusetts, Judge Story, go to the window, see if it's raining outside. And if it isn't, all the better. Because our jurisdiction is over such a great expanse of territory that it must be, the law of chance says, raining somewhere. And please pour the wine. I don't want to give a picture that they were tipsy all this time, but they were human. And there was no great Supreme Court building, as Jim has pointed out, until FDR's time. How ironic. The cases that grew out of the shift of power from the Federalists of George Washington to the Democratic Republicans, as they first called themselves. Today, they're called Democrats by some, Republicans by others. Depends who's in the White House and what they have on the website. But the great struggle took place because of that midnight round of appointments of John Adams. The first was John Marshall. How did John Marshall, who never went to college, except for one semester at William and Mary, between tours of duty and the Revolution, and reading Blackstone's 3 volumes of commentaries, the latest bestseller for lawyers from England, how did he get to be Chief Justice? Well, he read just enough to be a Virginia lawyer, because the typical setup for the colonies that became the states was very much like England's at first. In Virginia, you had county courts with county judges, and lawyers like Patrick Henry, who read 1.5 books to prepare for his bars. How do we know it was 1.5 books? Because he borrowed a 2-volume set from Thomas Jefferson and returned volume 2 uncut. But he was a great orator, and he had studied his classics. He knew Cicero, and he knew Livy, and he knew Horace. And you were examined by the judges on the Royal Supreme Court of the province. And the man who gave us the "Give me liberty or give me death" speech was a practicing attorney in Virginia with only that little bit of education. John Marshall's father was one of those lawyers. John Marshall was a more skilled lawyer. He practiced in Richmond, and he was getting rather wealthy as a lawyer in the 1790s, when George Washington became terribly afraid that Jefferson and Madison would tear the country apart because they believed in states' rights, and they were working to undermine Adams and the Federalists. So it was Washington who personally put pressure on John Marshall to stand for Congress. And as a member of Congress, he was asked by the next president, John Adams, to go to France to negotiate with Prince Talleyrand over the capture of American ships in the Caribbean. It's known as the XYZ affair. And John Marshall sprang into public notoriety because he was one of the commissioners who were supposed to come up with bribes for Talleyrand before he would see them. So he came back from France just at the time that Jefferson was defeating John Adams for re-election. And one of those late-night appointments was John Marshall as Secretary of State. So as they stayed under the stairs that last night of Adams' presidency and signed the commissions and put the Great Seal on them, it was John Adams who did the deed, including on his own commission. Madison came in as Secretary of State the next day after John Adams left without staying for the inauguration of his successor. The blood was so bad. Madison came in the next day, and he found a commission on his desk. Somebody had missed them before taking them around, running off on horseback. It belonged to William Marbury, who was supposed to be a justice of the peace in Washington, D.C., and he needed the money. He was counting on the political job. Madison filed it, deep filed it. Marbury never got his commission. But the new Chief Justice, John Marshall, who was appointed by Adams on the way out of town, the new Chief Justice, John Marshall, decided that Marbury could not have his commission. Marbury made the mistake of applying to the Supreme Court for a writ of mandamus, demanding that he be given his commission. And John Marshall established our whole doctrine of judicial review of the rest of the government by saying the Supreme Court did not have the authority under the Constitution even to give a writ of mandamus. It did not have the power. And that is the first time that anyone said what the Supreme Court had the power to do or not to do. John Marshall limited the power of the Supreme Court before he limited the power of Congress. That wasn't the end of the affair. Between 1801 and 1803, Thomas Jefferson threw out entirely not only all the appointments to the judiciary, but he fired 1/2 of all government workers, the top half. He fired judges, customs collectors, U.S. Marshals in every state, down to the lowest tier where there were nothing really above customs inspectors and postal delivery men. He absolutely destroyed the Federalist Party and any notion of a two-party system in 1802 as he gutted the Federalist Party. But he was suspicious that what the Federalists were doing was hiding in the courts, and they had to be rooted out. So you have a personal struggle developing by 1803 between Jefferson and John Marshall. Marbury versus Madison was only the first example. In 1803, Bonaparte Napoleon was out of money. He had just lost an entire fleet in a day, the Battle of Trafalgar. He had thus lost the way to sail his armies to invade England. He was looking for money. He had conquered the Spanish peninsula, the Iberian Peninsula, and what he did was annex the west of the United States, Mexico, most of the Caribbean surrounding territories, and most of South America. But he was willing to sell it for $11 million cash on the barrelhead to the United States, so that he had the money to carry on the Napoleonic Wars. Jefferson studied the Constitution. He saw that the President of the United States did not have the authority to single-handedly buy the Louisiana Purchase from Napoleon. He also found out that Napoleon did not have the authority to sell it. This may be the biggest bad deed in legal history. But the sale went through. Congress did not have the nerve to tell Americans that they couldn't keep going west. So Congress did nothing. Jefferson said nothing, saw nothing, and we paid about 3 cents an acre for 1/3 of the United States. Marshall decided that he could not intervene at this time. But what he did was systematically begin to chip away at the initiatives of Jefferson and the Democrats as they tried to expand into that new territory. So by 1807, another one of our bad boys of history, Aaron Burr, decided that the Louisiana Purchase lands should be split away from the United States, and he organized an insurrection, or planned one, along with the general of the Army, General Wilkinson. They were supposed to get together on an island in the Ohio River with 1,000 men and enough money to go down the Mississippi and attack Mexico, Texas, Florida. I mean, the ambition of these men was so amazing. But Aaron Burr was on the lam already because he had shot somebody that a lot of people would want to line up and take a shot at the time. He had shot Alexander Hamilton in a duel in 1804. So he was under indictment for murder in New York and New Jersey. He had also had the nerve to go back and preside over to the Senate until his term was up. But now he was going to invade Mexico, Texas, and Florida and form a new Caribbean empire under Aaron Burr. Well, the plot fell apart because Wilkinson, his partner, basically told Jefferson, and Jefferson sent U.S. Marshals, and they caught Aaron Burr in Alabama, and they dragged him back for 12 days on horseback. So Aaron Burr, who was a very fastidious gent, arrived in rather bad shape in Richmond, where he was tried for treason. And this is one of the most interesting clashes, I think, between Jefferson and John Marshall. First of all, Jefferson personally took over the prosecution. He was president, and yet he was running the prosecution in a Virginia court. He insisted it be in Virginia because he had already found out no grand jury would indict Aaron Burr west of Richmond. So the trial took place in Richmond, Virginia. It went on for months. John Marshall, as Chief Justice, was also responsible for the Virginia Circuit Court. So rather than let the court get to the Supreme Court, he stepped down and presided over the trial in the Circuit Court in Richmond. Jefferson was furious at Marshall for outmaneuvering him. But 3 times they tried to convict Aaron Burr. And they never were able to prove the most important point, that he'd been in Virginia during this plotting. There's a problem. Somerset Island, where the plot supposedly took place, is in the middle of a river, and it really isn't Virginia. But these fine distinctions hadn't been worked out. Jefferson failed to nail Aaron Burr. Aaron Burr escaped, and he became the inspiration for a famous book we all read once upon a time called A Man Without a Country. He went around Europe for 11 years trying to find somebody else to plot with to overthrow the United States. Returned, never indicted to New York, was a rich and successful lawyer, married a rich old woman, and went on until his 80s. Students need to know this, I think, that these are real human beings, that these were dynamic personalities, and what they did wasn't always a great contribution. So the Burr case collapsed, but systematically, John Marshall began to lay down the laws of the nation as it expanded west. In 1810, 3 years after the Burr case, the case of Fletcher versus Peck came to the Supreme Court on appeal because what was at issue was 35 million acres of what they called the Yazoo Strip, Mississippi, Alabama, Georgia, part of Florida. It had been sold by the Georgia legislature for $500,000. The problem was this fire sale involved members of the legislature who put up the $500,000 and were buying much of the Gulf Coast for $1.50 an acre. Voters learned that the legislators had personally profited, bought the land, and sued to get the money back. John Marshall then decided that the legislators, even if they were corrupt, even if they had scammed the public for all of that land, the contract was valid. And John Marshall said that the sale to Georgia and its legislators had to stand. Again, it's hard to describe Jefferson's reaction. By this time, he was sputtering out of office instead of in office against John Marshall. But that case remained in the court for 15 years, and finally, John Marshall's decision meant that the contract was sacrosanct. And this is the first example where John Marshall decides on the future of the country that it is the duty of the Supreme Court to protect the individual and the contracts that they sign from the power of the government. So here, for the first time, you see what we call now a balance of powers. 1816. The War of 1812 was over. Amazingly, the United States didn't lose. England got tired. But when it was all over and Andrew Jackson had a victory after the war itself was over, it had a new hero and it faced west. And the people really wanted to expand rapidly into the interior. They wanted the Congress to approve money to build canals, to dredge rivers, to build national highways. John Marshall, with his unanimous decision of the Supreme Court, declared, "The power to regulate commerce among the states cannot include a power to construct roads and canals." Where would we be if at some later date that wasn't reversed? If after the internal combustion engine had made it necessary to have national highways, or after Dwight David Eisenhower had blessed our interstate highway system. But John Marshall thought that the states in this case had the power, and it should not be turned over to the national government. No matter who the Democratic Republican presidents appointed to the Supreme Court, Washington seemed to win them over. He wrote, as I said, one dissenting opinion in 34 years. His intellectual power and his charm seemed to win over all his opponents, not just to say the glass of wine, and the friendship of five men working closely together year in and year out. One of the most famous cases involved another one of our early giants, and that was the case of Dartmouth versus Woodward. The lawyer for Dartmouth College was Daniel Webster, an alumnus. And here again, it was the contract clause of the Constitution, of Article 3, that was so important. The president of Dartmouth was deposed by the Board of Trustees. He appealed to his friends in the New Hampshire legislature. They tried to take over the Dartmouth Board of Trustees, invalidate its charter, and reappoint the deposed president as the president of the new Board of Trustees, and all other trustees be appointed by the state legislature. Again, Marshall argued that the sanctity of an original charter, like any other contract, had to be respected. Dartmouth had been chartered by the King of England in 1769. And the U.S. Supreme Court ruled that a royal charter to a college trumped an act of any state legislature. And this established the fact that college boards of trustees or any institution was protected from legislative takeover. So Daniel Webster prevailed in this case, and the Great Seal, the records, the cash box, and the buildings of Dartmouth were returned to the control of the Dartmouth trustees. Webster's words, I think, that swayed John Marshall most of all, he says, "It's a small college, yet there are those who love it." What can you say to an argument like that, especially since it was much shorter than Webster's arguments usually were? 1819 is probably the most important case to come before the Supreme Court in the 19th century. McCulloch versus Maryland, 1819. The Second Bank of the United States had been created in 1816 after the war, Second War with the British, and it had the right to issue banknotes. But in Maryland, where it was based, it functioned as an ordinary bank as well. So the state of Maryland took the Bank of the United States to the Supreme Court, basically for unfair competition, because the Bank of the United States was tax exempt and wasn't paying any taxes to the state of Maryland. John Marshall argued that the federal government was not created by the states, but it was created by the people, that the Constitution was made by the people and not by the individual states, and that law of the people took precedence in all matters, not specifically in the Constitution. So anything that wasn't in the Constitution was also covered by the spirit of the Constitution, power from the people. And this really is the case that established the principle that federal law takes priority over state law at any time. The next year, 1820, Gibbons versus Ogden, gave rise to the entire regulatory power of the United States government. Listen to this, it's like a drum roll, year after year after year. More power, more power, more power to the Supreme Court. Gibbons had tried to run steamboats between New Jersey and New York. But New York had granted a monopoly to Robert Fulton, the inventor of the steamboats. And the inventor had a business partner, and they were using New York's waters exclusively. Gibbons from New Jersey took the case and appealed it all the way to the Supreme Court. John Marshall. New York's law was in violation of the Constitution and its provision that gave Congress the power to regulate commerce among the several states. So our entire regulatory apparatus, federal regulatory apparatus, dates to that decision, Gibbons versus Ogden in 1820. And Gibbons was allowed to run his steamboats back and forth across the Hudson River too. That same year, a case came from Virginia. And these all seem to be sort of peripheral, maybe even ephemeral cases, until the Supreme Court under John Marshall gave them meaning. The Cohen brothers of Virginia were selling lottery tickets for a lottery being run in the District of Columbia, but they were selling the tickets in Virginia as well. So Virginia sued the Cohen brothers, and it went up to the Supreme Court. First, the Virginia legislature haughtily told the Cohens, quote, "A sovereign and individual state is not liable to the suit of any individual, nor amenable to any judicial power without its own consent." That's not what John Marshall thought. Marshall allowed Virginia technically to win. The Cohen brothers were not allowed to sell Washington, D.C. lottery tickets in Richmond anymore. But the Constitution, Marshall decreed, the Constitution and the laws of a state, so far as they are repugnant to the Constitution and the laws of the United States, are absolutely void. So anything the Supreme Court doesn't like means the state laws are void. By 1829, in the case of Boyce versus Anderson, you get the doctrine of federal control of common carriers. Boyce had shipped slaves down the Mississippi on a steamboat. The steamboat caught fire. The slaves drowned. Boyce sued for insurance for lost freight. John Marshall said, "A slave has volition, and he has feelings. It cannot be stowed away as a common package. In the nature of things and in his character, he resembles a passenger, not a package of goods. The most important case in Marshall's lifetime was when South Carolina tried to nullify the tariff laws of the United States and threatened to secede. And John Marshall made that impossible and said it was illegal. And he decreed that it could not happen, that the federal government could not stop the state, and the state could not secede. Immediately after that, Andrew Jackson, the slave owner from South Carolina, decided that slaves from Georgia should be deported in large numbers, Cherokee Indians, 1,000 miles to the west. And when John Marshall said that that was unconstitutional, Mr. Jackson said, "Mr. Marshall has spoken. Now let's see what he can do about it." So you can see how far they had come. Marshall himself, by the time he died, was in doubt over the future of the Supreme Court, not even recognizing the importance of what he had done. He said he had come slowly and reluctantly to the conclusion that our Constitution cannot last. The Union has been prolonged thus far by miracles. I fear they cannot continue. Soon after that, John Marshall went to Philadelphia for an operation at Pennsylvania Hospital and died on the table. And when the news got around Philadelphia, the Jeffersonians got in the last word. They rang and rang and rang on the Liberty Bell. And it has never sounded again. Thank you.